Talk shoes. Recorded live.
All right, ladies and gentlemen, this is Rod. A couple things I want to bring up to you. One is Title 18, Part 1, Chapter 101, Section 2071. And Title 18, Part 1, Chapter 101, Section 2076. Look up both of these. These are the federal statutes that they cannot tamper with our court filings, which is what they're doing in my case. They are not filing my paperwork in. The court has to file. Failure to file any paperwork is tampering. These are federal offenses. Look up these case laws, or look up these federal statutes. The other thing you want to look up is judges and clerk of courts violate the law when your court filings are denied or disappears. Look this up on the internet. I will say it again real slow. Judges and court clerks violate the law when your court filings are denied or disappears. Look this up. It's got a bunch of case law and the federal statutes I just gave you, Title 18, 2076, and Title 18, 2071. Very important. Now, I'm here to talk to you about winning another administrative hearing. I have successfully won another administrative hearing here in North Carolina against the State Highway Patrol. We had the Attorney General for North Carolina come in and defend the governor's office, his office, and State Highway Patrol and Department of Transportation, because under the SF-95 tort claim and under the Administrative Procedure Act of North Carolina 150B, it says if you have a problem, you are to notify the agencies for an administrative remedy. Well, the Attorney General, again, has come back in and has addressed the fact that the governor is not ahead of the administrative agency, therefore he is not liable for the State Highway Patrol or any other agency in the state. Now listen to what I just got done telling you. The Attorney General filed into the administrative court telling the administrative court that the governor's office is not ahead of the administrative agencies of any agency of the state. Therefore, he is not liable for the agencies. Department of Justice, the Attorney General's office, is that they are not responsible for the agencies. And that the State Highway Patrol is also not an agency of the state. And the administrative court upheld the request and denied my document about the State Highway Patrol being an agency, and that the governor and the Attorney General are not agencies of the state. Therefore, there is no one ahead of any of these agencies. Now, I'm going to give you some case numbers of what we have done. In 2007, Rodney Class versus United States of America, case number The 10th Circuit Court of Appeals defined all defendants as corporate appellees, the United States of America being the main defendant in this action. In 2007, the 10th Circuit Court ruled that the United States of America is a corporate appellee because they were the main defendant in the case in 2007 for a class action. Rodney Class versus North Carolina, DOT in Dallas. Administrative Court, 10, DOT, 7047, 2010. This is the one where the administrative hearing ruled that the police department are private contractors and not agencies of the state. Rodney Class versus North Carolina. Judicial review. Again, we went back on judicial review on that case. It was a CVS 11 CVS 1559. The Administrative Review Court ruled that the police department is private contractors. They're not agencies. Rodney Class versus North Carolina Tax Department, 12, REV 05184, 2012. The Office of Administrative Hearing, Raleigh, decided that the tax department was not a state agency and that the employees are private individuals. Rodney Class versus North Carolina Department of Justice, 11, DOJ 09708, 2011. The Administrative Court decided that North Carolina Department of Justice and defendants are not state agencies or agents under the state of North Carolina. This latest one, Rodney Class versus the Governor, Department of Justice, DOT, State Highway Patrol, 14 GOV 3404, not a state agency, employee. Ladies and gentlemen, we're getting the rulings on this. In our first case on the Dallas Police Department and the DOT, in our first administrative hearing where I got the court to rule that they were private contractors. That's significant. The other judicial review we got on that went back in and ruled and upheld their private contractors. The case that dealt with the Department of Justice dealt with me going in Charlotte, going after the Department of Justice, Mecklenburg Court System, the Prosecutor's Office, the Sheriff Department, the County Jail, and Mecklenburg Police. Under that Department of Justice, that 11 DOJ 09708, they ruled that the Sheriff Department, the County Jail, the Court, the Prosecutor's Office, the Police Department, and the Department of Justice was not agencies of the state. Listen to what we're saying here. When I did the tax case, and we got the tax department under 12 REV 05182. We got them to admit that the tax department is not an agency of the state, but they're private individuals. This last hearing that I did with the State Highway Patrol going after the governor, the Attorney General's office, again, DOT, because they come under the Highway Safety Act, and the State Highway Patrol because they come under the Safety Act. The court ruled that they're not agencies of the state. That 2007 case was our class action. We went after the United States, the governors, the judges, and the banking system, and the 10th Circuit Court came back and ruled that they were not public offices, but corporate appellees. Ladies and gentlemen, we have got seven wins on this. We have gotten 7 very significant administrative rulings on this of what we have done and how we have went in on the administrative side and opened this thing up. It is very significant because, ladies and gentlemen, what we have done and what we are teaching and what we're getting into under these SF-95s is that we are coming back in and showing that when the state comes in and acknowledges that they are not state agencies, they have acknowledged the fact that they have waived their immunity of these public officials. They have waived their immunity because they acknowledge they don't work for the state. There is no agencies. Ladies and gentlemen, this is a very, very significant, very, very significant issue of what we are talking about and what we are explaining here. We have successfully gotten 7 rulings. I have got 4 administrative court against Dallas Police Department, DOT, against Mecklenburg Sheriff Department, County Jail, the court system, the prosecutor's office, Mecklenburg Police Department, and Attorney General's office. We got the administrative court came back and ruled they're not state agencies, so right there's 2. Third one I did was against the tax department of Gaston County and of North Carolina, and I got the ruling that they are private individuals. I have successfully went after the governor, the Attorney General's office, DOT, the State Highway Patrol, and they came back and ruled they're not agencies, and the governor is not ahead of any agency. Therefore, there is nobody ahead of the agencies. So that's 4 administrative rulings. I've got 2 reviews. One for the Dallas Police Department, where Ridgeway came back in and ruled they are private contractors. One for the tax department against North Carolina, Gastonia. They ruled that they're private individuals. And the 10th Circuit Court case where the United States of America was involved. The governors were involved. The State Justice Institute was involved. The judges were involved, and banks were involved. and the 10th Circuit Court came back and ruled they were corporate appellees. Ladies and gentlemen, this is significant. This is significant of what we are coming back in and proving we do not have a government. Nobody is in charge. We're sitting on 7 rulings now. 4 straight from the administrative court, 2 from judicial review, and 1 from the 10th Circuit. That's 7. We're proving that nobody works here. We're proving that these offices are vacant. We're coming back and showing that when they come back and show that nobody works here, they have stripped them of their immunity. They now can be sued in their private capacity for impersonating a public official and impersonating that public office. This is the significance of the SS-95 forms. This is the significance of bringing administrative claims into the agency and having them sit back and deny their position or sit back and fail to answer you. You got 2 things in your favor here. If they fail to answer, then they have acknowledged they don't hold that office. If they come back in and say they do not represent the agencies, that is a confession. You take this to the administrative court, and the administrative court upholds this. They have stripped them of their immunity. This is what we're doing in Washington, D.C. in this federal court case. All you people who file these SF-95s in, ladies and gentlemen, you are sitting on a federal tort claim. When the judge has denied the paperwork, you're sitting on a federal, because he has admitted he has no jurisdiction and no subject matter. He is acknowledging the corruption, that the prosecution had no jurisdiction and no subject matter. Ladies and gentlemen, you that file into this federal court case, you have a federal tort claim. My friend in Ohio, his attorney pulled him off to the side because he was filing paperwork as a third party into this. He brought charges against the lawyers. His attorney told him, says, "You realize what you've done?" He says, "No, not really. Now that we brought charges," he says, "You realize that you have successfully," and this is why they're not answering your paperwork, by you going after them, you have now went after their insurance company. If they lose their bond. They lose their job. They can no longer be lawyers. They can no longer be judges. Ladies and gentlemen, this is significant, very significant on the administrative side. This is what's going to be part of this judicial review form out here at Cross Country Campground in Denver, North Carolina, at 6254 Highway 150 East. That number is 1-800-852-4840. This is going to be part of the teaching on this judicial reform, is to educate, to get you to understand, to get you to realize if we go after them administratively and they fail to answer, this is what you want. You want them to be silent. And then you take them into the administrative court. Now, you may not have one like I have here in Raleigh. You may have to take them into county court and turn it into an administrative court. Ladies and gentlemen, that's how it is in Indiana. Do not let that discourage you. because you want that county court to come back in and state that they are not agencies of the state. They're not employees of the state. Because the moment they do, they have waived their immunity. Now you got a federal tort claim. You now have a federal tort claim against these people. This is part of what we're getting into. But again, I want to sit down and I want to draw your attention to Title 18 under 2071 and Title 18 under 2076 of tampering with your files. They can't tamper with your files. They have to file them. This is part of what we're dealing with administratively. When they fail to answer, when they fail to turn around and comply, we have them in the fraud. But I have successfully, in North Carolina, I have won 6 administrative court cases where the administrative court and the attorney general have come back and admitted that these people are not part of the agency and that the governor is not ahead of the agencies and that the Department of Justice is not ahead of the agencies. Therefore, they're not liable. And the Highway Patrol is not an agency. So we have successfully took out the State Highway Patrol, the County Sheriff Department, and the police departments. We have successfully took out the tax department of the state and the county. We have successfully took out the court system, the judges and the prosecutors. We have went in and showed where the county jails are not part of the state. And on the 10th Circuit, we have showed that the United States of America is listed as a corporate appellee. We have successfully done 7 cases between 2007 and 2014. We have done 7 cases showing that nobody works here. This is to our benefit. This goes back and proves we don't have a government. This validates the fact that we do not have a government. These administrative rulings goes across this country, not just North Carolina. Ladies and gentlemen, this is why we're teaching this. This is why we're trying to get you to understand. We need to start going after them administratively. Because when they admit they're not part of the administration, then they admit they do not have a job. If they admit that they are part of the agency, then they have admitted they have created a crime and violated your rights. This is a lose-lose on their side of the fence. Under the Highway Safety Act, the governor, under Title 23 U.S.C. Code 402 and Title 23 CFR 1327 and 1250, the governor has to agree to the Highway Safety Act in order to fund the Highway Safety Program, which goes into the DOT, the DMV, and the police departments and the State Highway Patrol. He has to sign the contract, the treaty for the federal funding. We just got them to admit he's not ahead. They have now embezzled federal funding. They have now impersonated public office in order to receive federal funding. This means all these CAFR accounts that they have was based on fraud because nobody was there. They cannot use that constitutional office to obtain federal funding, and then when they are charged because someone has violated their administrative procedure, for them to come back and say, oh, we're not an agency and we don't have any control. That agency is not underneath me. They cannot embezzle federal funding on the constitutional side and then claim no responsibility. This is very significant, ladies and gentlemen, what we're doing here. This is why you're filing SF-95s into my court case. We're proving, when the judge denies it, he is proving he has no subject matter jurisdiction because he can't prosecute the prosecutor because he has no authority, because the prosecutor doesn't have any authority in the courtroom. These are very significant, very, very significant of what we're doing here. We're proving absolute corruption. I'm going to make this short because I just wanted to bring out, I just got my ruling just here the other day from the administrative court acknowledging the State Highway Patrol is not an agency of the state, and the governor is not responsible for any agency underneath him, and the Department of Justice, which is the Attorney General's office, is not responsible, and therefore it doesn't represent any agency. Now, isn't this quite funny? We got the ruling. Thank you. Have a good evening.